Welcome, listeners. I have exciting news that you may or may not have seen on the Legal Paige website, on Instagram, and all over social media, and our Facebook page, but I wanted to share it with you all today. The Legal Paige now has contracts available to Canadians. That's right. If you're a Canadian entrepreneur, we are now able to help you get legally legit. We are working currently with our Canadian lawyer through every single template contract that we have that is an American contract. And did you know that we have well over 300 plus contracts? So our Canadian lawyer is helping us convert them into contracts that can be used by Canadian business owners. And to see what we currently have in our catalog available for Canadians, head over to thelegalpage.com/Canada. Again, that's thelegalpage.com/Canada. Now, I want to introduce you to the lawyer that we brought on board to help make Canadian contracts come to life. Courtney is a Canadian lawyer with a general practice based in rural Saskatchewan. The bulk of her work as a lawyer is focused on corporate law, real estate, and wills and estates administration, as well as now small business law. She is a wife, mother to a newborn baby early this year, and lives on a mixed grain and cattle farm with her family. So the Canadian catalog would never have been able to happen without the help of our gal Courtney and my good friend now, which we vox her back and forth all the time and talk about all things happening for Canadian small business owners on a daily basis. And I am overjoyed and excited to finally have her on the podcast today and really take a deep dive into the differences between Canadian contract templates that we sell at thelegalpage.com and our most used US-based contract templates. So without further ado, Legal Pagers, let's get into it. You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. I am an attorney, but I am not your attorney. All legal information I talk about in this episode is intended for the masses and a large variety of different businesses. Please seek out another attorney in your city and home state if you need specific legal advice related to your unique business. Okay, let's get back to it. Thanks again for listening to today's podcast. Courtney, our Canadian gal over here at the Legal Page, is joining us today to talk all about the differences with Canadian contracts, because in case you missed it, the Legal Page has expanded to Canada. Woo! Which is so crazy. I am literally excited and overjoyed because when I first started at TLP, I had some very straightforward passions, and that was to help all business owners get legally legit. And that was really within the United States. And I never in my wildest dreams could have thought that it was going to grow into what it has today. And here we are going international. So Courtney, thank you for joining us.
Thanks for having me, Paige. I'm really excited to be here.
I'm so excited as well. We've been doing so many back and forth, so many Voxers, so many emails, and here we are finally talking face to face. I mean, we've been on a couple Zoom calls before, but this is fun because we really get to introduce our TLP audience to the lowdown on all things Canadian contracts. So Courtney, before we get started into all of the nitty gritty, could you just give our listeners a little insight into who you are and your background as a lawyer?
Yeah, absolutely. So I was born and raised in rural Saskatchewan. It's where I practice law. And it's given me a really unique perspective when it comes to the law, just with all the issues that exist with access to justice in Canada. I wish I had some sort of amazing story about why I wanted to become a lawyer, but truthfully, I just always thought it was something that I would enjoy. I've always liked pushing myself, and I saw law school as a challenge, which it really was, but I don't have any altruistic, I wanted to save the world. Unfortunately, I wish I could say that, but it was just a feeling for me, really. And my background of being in rural Saskatchewan, that's actually what kind of led me to finding TLP because I'm kind of in an isolated area. I don't have a big legal community around me. So when I was doing my articles, I was actually, just scrolling, looking online, trying to find people in the legal community that I might be able to connect with. And I came across TLP, and I just loved what you were doing. I thought it was such a clever idea, and I could see how something like this would help with the access to justice crisis in Canada, because it kind of gives an affordable alternative for companies to make sure, as you would say, they're legally legit. So I wanted to follow along with your business, and I was hoping that you might expand into Canada at some point, because it seemed like such a great idea and something I just hadn't seen on our Canadian market. So one day you were looking for, an associate attorney, and I think I just responded and said, "Oh, I wish you were based in Canada. Like, this sounds so amazing." And I guess the rest is history.
It is history. Yeah, we were looking for an associate kind of at the beginning of 2022. And you had followed me on Instagram, and we were like talking back and forth. And then I was still like just coming fresh off maternity leave. And then you were also in like new mom mode as well. And it's been really fun to do that journey together. So I think we connected there. And you kind of like put that little bug in my ear in terms of, oh, I think I should go into Canada. And here we are in Canada now. And we're very excited to continue to expand and bring on new affiliates, and we're going to talk about it in this episode, but get to our entire catalog, which is very, very challenging because apparently I have way too many contracts, and I didn't really realize it until you actually look at the full breadth of the catalog and contracts that we have. So, Courtney, let's just get into it. Let's chat about the big, big differences between Canadian contracts versus US contracts. And really the legal system up there in general, because, and I say up there, you guys, because I'm in Montana, so it's like boom, right above me. If you're in Alaska, it's like to the side of you, so just FYI. If you don't know geography. Anyway, okay, moving on. I'm sure a lot of our listeners just really aren't aware of how similar and how different certain laws are in Canada. And so we may seem kind of like two similar countries in a sense, because we do share a border, and we do kind of go off of the same general British legal system. That's kind of where we were all, expanded from. We just offer kind of different legal services in a different realm, but lawyers are very common in both countries. And then just really business contracts as a whole, it's been interesting for you and I to kind of delve into the fine print of our contracts, and for you to be like, this would be a little different up here, or yes, this same specific clause would apply in Canada as well. So before we go any further, I do want to remind you that if you are a Canadian entrepreneur looking for a Canadian contract, I want you to do this. I want you to head over to our website and click Shop by Product, and then the Canadian catalog. That is going to tell you all of the different contracts that we currently have at the Legal Paige for Canadian business owners. And I just wanted to put in this little tidbit that we are working on adding a bunch more. We have over 300 products in the Legal Paige shop, and we only have one Legal Paige and one Courtney Canadian lawyer. So we are working on converting all of those to Canadians with the help of our friend Courtney here. But we're doing kind of our most purchased contracts first, and purchase addendums and, a la carte clauses. And it will take us some time to build up that Canadian catalog for Canadian business owners to be all of the contracts that we have for US business owners. But we're getting there, and we're really, really excited. So you will see quite a few in there right now. And if you're listening to this episode and you're like, hey, I don't see my contract in there for my specific business for Canadians, hit us up, let us know. Email us, or hit, DM me on Instagram, and Courtney and I will make sure that we put that to the top of our list. So, okay, with that being said, Courtney, just give us a big overview really quick, and then we'll keep piecing it together and, just going through all of, the really intricate pieces of the provisions of contracts. But what are the key differences between Canadian law and US law in terms of contracts that our users should be aware of?
Okay, so you kind of touched on it at the beginning. There's definitely a lot of similarities, obviously, in our legal systems. But I would say that the biggest difference is generally the boilerplate clauses. Those are the ones that are really going to differ. This is because the Canadian courts have been really clear about how they're going to interpret contract clauses when there is a dispute. So we need to be incredibly careful with the wording that we're using to make sure that the meaning of the clause is clear to everyone involved. We don't want to see the courts, review a clause and say, well, no, actually, it says this, so we're changing the meaning. So we just want to be really, really clear so that there is not going to be a dispute over what a clause means. Another huge difference between the two jurisdictions, not necessarily actually within the contract, is the type of damages that are going to be awarded. Canadian courts rarely offer high rewards for damages in any case, whether that's a contract dispute or otherwise. The only way you're really going to see a high reward is if there was some sort of conduct that was malicious or like highly reprehensible. But again, that is such a rare case to prove. So don't think, if there's a dispute, you're going to go to the Canadian courts and, win $1 million. That's just highly unlikely. And it's also really common for Canadian courts to offer awards on costs to the winning party. Now, I don't know what the standard is in the US on this, but in Canada, like what that's going to mean is if you go to trial against somebody in a contract dispute and you win, the other party might be ordered to pay your legal costs up to that point. If you're going all the way to trial, you're spending upwards of $50,000 in legal fees a lot of times. So that's a huge chunk of money. And that's really important for Canadian business owners to be aware of, and why it's so important for them to make sure that they have all their bases covered when it comes to contracts, because you don't want to see at the end of the day, if something doesn't go in your favor, and then on top of that, you're ordered to pay someone else's legal fees, that's going to be a huge hit to you and your business.
Oh, absolutely. Yeah, that's a big difference, because just based upon, being a law clerk and seeing behind the curtain, people are very litigious in the United States. And I do think that, high rewards are a little bit more uncommon, but just general, compensatory damages, and maybe a little bit of punitive damages aren't unheard of here in the United States. You probably see court cases all the time if you're listening on big, big cases that have millions of dollars in compensatory damages and punitive damages. On that, I'm kind of going on a tangential note here, but I think it's really important to note that for business owners, essentially, we're kind of giving a broad overview here of what could happen and the things you want to be prepared for. And our TLP contracts make it really clear what type of damages you can and cannot get, and the maximum of damages that can be awarded. So in the United States, we try to rein that in quite a bit. So our US contracts always say maximum damages are the amount of the actual contract, and no additional punitive damages could be awarded by, to either party, by, the judge or the jury if you were to get into litigation. And go to trial, as Courtney was saying. And obviously that's the same up in Canada. We're going to have those same provisions in our Canadian contracts, but Courtney's just making it clear that it's even harder to get damages up there in Canada. So that's super interesting. And we just make sure that is as concrete as possible in our contract provisions, whether that's US-based contracts or Canadian-based contracts. Now, Courtney, when you were first reviewing our best-selling template contracts, I think we started with a lot of the photography contracts, and some of our independent contractor agreements, and then some of our online coaching contracts. I know you noticed that we had specific provisions related to the services being performed, such as editing and posing and project timelines, which really didn't need a ton of modification, right? Because those are just specific provisions to the services you're being performed. There's no legal ramifications to those. It's just, what are your business policies? Your client's agreeing to your business policies on this. But you talked about more boilerplate clauses or general clauses that definitely needed some tweaking. Can you chat more about those for us?
For sure. So one of the most obvious changes was to the copyright clause. since Canada has their own laws on copyright, which are governed by the Federal Copyright Act. So I had to make some changes there. When it comes to photography specifically, photographs in Canada are considered artistic works under the Copyright Act, and they're protected by copyright from the moment they're created, which would be the moment the picture is taken. For digital images, the interesting part of that is that the author of the image is not necessarily the person who took the photo. It's going to be whoever owns the camera that was used to take those photos. Another change was to the indemnification clause, which I know this was kind of different in the US. As I understand it, Paige, you had kind of said like the US does not allow for first party indemnification, or that might be a state law, I'm not sure. But Canadian law does allow for first party indemnification. So in the most simplest terms, indemnification is when you agree to compensate someone for harm or loss. So first party indemnity would be a situation where party A is agreeing to indemnify party B for any losses that are a result of the conduct of party A. The important thing to note here in Canadian law is that it has to be really clear what the indemnity is being granted for if it's first party indemnity. So the general indemnification clause that you have didn't require a ton of changes, and it works perfectly for our third party indemnity. But a lot of the situations where we had first party indemnity, it's really clear about if, something happens to the wedding dress, I'll indemnify the photographer so they're not liable for any damages that I might have caused while wearing it, that kind of thing. Another clause that required fewer changes was the entire agreement and severability clause, as well as the no waiver clause. In the entire agreement clause, the biggest change was making sure that it clearly stated the agreement would be binding on the parties, their heirs, successors, assigns, to make sure that the parties' respective heirs, successors, and assigns are entitled to benefits and obligations created by the contract. The biggest change to the severability and no waiver clause was just being very clear that failure to enforce a provision would not be considered evidence as a waiver or breach of the provision. Essentially, we don't want someone to try and say, well, this provision is invalidated because it was not enforced, and then to use that failure to enforce in court as justification to have the clause struck from the contract. So we just wanted to make sure that, if you're aware that some provision is being violated in the contract, but maybe you didn't want to enforce it for whatever reason, that then that person can't come back in court if it gets that far and say, well, this is evidence that they didn't enforce it, so it no longer applies. And then one other clause that actually was identical between the US and Canada was your force majeure clause. I couldn't find any reason to change that wording from the American contract. And the clause used in the TLP contracts was actually so comprehensive already, I couldn't even come up with anything that could be added as a potential force majeure event. So I think you're pretty much covered on like any situation you could imagine.
I'm glad you mentioned force majeure. It's really funny. I feel like the force majeure guru of all like contract lawyers in the United States. I've actually been asked to lead some classes on it. I think it's because our industry was so hit by COVID-19 from like March to May of 2020, especially because of weddings and events. And it was such a big deal for us versus like businesses just shutting down. Ours was like the unknown of things happening those 2 months, that summer, and everybody in the wedding and event industry didn't have correct force majeure clauses. And so we really did work extremely hard to look at, case precedent on force majeure, which is really slim in the United States, to be honest. I think I knew, foreseeing what would happen in the future, is that courts are going to start looking at force majeure a little bit more post-COVID and post-beginning of the pandemic, which they have. We do have a little bit more case law in the past couple of years, but they're still willy-nilly on how they're enforcing force majeure. If COVID is a force majeure, it's so fact and circumstantial. But essentially, our force majeure clauses state that if something of a superior strength happens that is unpredictable and unforeseeable at the time of contracting, that's important because no longer is COVID force majeure, because it is absolutely predictable and absolutely foreseeable that it could impact the contract as a whole. And then it expressly delineates what force majeure events are, and then it talks about the impacted party. So if someone were to be impacted, say, by a hurricane, I think most people understand force majeure events to be like hurricanes, acts of God, avalanches, mudslides, wildfires. You can most people know that it's like those type of superior strength things happening. Then the impacted party would tell the other party or parties to the contract, hey, I can't perform under the contract due to this force majeure event. So I need to have a delay on my performance or a pause on my performance. They notify the non-impacted parties, and then hopefully they perform within a certain period of time. Usually it's 15 to 30 days. If they don't and performance can't happen, then it doesn't constitute a breach. It just constitutes kind of a mutual termination of the contract. And then you have to decide what happens to fees paid. And that was a big thing that was missing with all service-based contracts in the middle of COVID is force majeure event, force majeure clauses kind of said what I just mentioned, but they had nothing in regards to fees. So then all kinds of clients were claiming, I want a full refund, a full refund, a full refund. But it's not like you're ripping up the contract. Force majeure clauses are really just allowing this grace period with performance and allowing performance to be rescheduled or the contract to be reinstated at a later date. And so we just always have something at the end of that clause regarding fees paid. Lots of people love it when I talk about force majeure. So that was as quickly as I could chat about it as possible. I'm glad you talked about copyright clauses, you guys. Essentially, you just need to know that we are based on the Copyright Act here in the United States, and they are based in the U.S. Copyright Office. And Canada obviously just has a different office. Very similar provisions, very interesting about who owns the camera, though. That is not how it is in the United States. It's the actual person physically composing the shot and pressing the shutter. Especially for independent contractor relationships, if you were to loan out a camera, which I don't ever recommend. But in those situations, again, and we haven't really talked about this too much, Courtney, and I'm sure we'll get into it with independent contractors, but we always have a work made for hire provision in those type of contracts where the copyright is always owned by the owner of the business. And if you have a contractor, obviously for copyright purposes, usually the person who's composing the shot immediately owns the copyright, but then you can have another immediate assignment to the person the company that you're working for. And so that's what a work made for hire clause is. It says, I know that I usually own the copyrights when I first click the shutter, but I'm going to assign it to the company that I'm working for as a contractor for their business. The indemnification clause, yeah, they're very similar. We just don't have, and this is good to just chat about in general for people listening in, indemnification is tough because it is extremely state-based here in the United States. And so you're going to get 50, 51 plus different interpretations by case precedent in your state regarding indemnification. And first-party indemnification that Courtney was talking about, it's more allowed up in Canada. And here in the United States, they don't really like first-party indemnification, and they don't like indemnifying for your own negligence. So as a whole, to just make our template contracts as templatey as possible, we always just have third-party indemnification, which is the scenario that Courtney was discussing. If something were to happen with a third party at the wedding and event that you really are so tertiary to that situation even happening, they can't come and try to sue you. The guests or the clients of yours or the guests of the clients can't basically bring in all of these defendants to a lawsuit just because they're vendors at the wedding. And so it's one of these clauses that allows you to bow out of that kind of lawsuit really quickly. A motion to dismiss here in the United States. That's what that kind of indemnification clause is really trying to do, is prevent you from being liable in any way, shape, or form to third-party claims. Obviously, if your clients have claims against you as a business owner, it's really, that is what your contract is there for. You're going to have provisions in your contract to prevent that. And honestly, it's between the two or more parties to that contract, you as the service provider, to try to come up with a mutual resolution to this legal issue, hopefully before it gets to litigation. And then a severability and no waiver clause. Yeah, we also, of course, have that in American contracts as well. But just like Courtney said, more very specific language up in Canada, which as a whole is fascinating to me. Okay, so let's move on a little bit here, because I think it's important to talk about not only just service-based contracts and the clauses within them, but other contracts that people need as well. Before I move on to this other contract I want to touch on, I want people to know that if you are ever wondering what clauses are actually in our contracts, we have a cheat sheet for you at the Legal Paige, and it's really nice to be able to do this. If you go click on a product at thelegalpaige.com and then you go to the tab that says clauses included, it will literally give you a checklist of all of the headings of the clauses that we have. So the ones that Courtney and I are talking about here today, the additional ones that we put into our Canadian contracts, all of those headings are in that list. And so we don't like to hide anything here at TLP, and I want you to know exactly what you are going to purchase before you actually press, the click to order button on your checkout page. So let's move on, Courtney, to a website terms and conditions and privacy policy, because I know this was a big one that you looked at for us. And I was really interested to have you look at this one because really, as we all know, the internet is worldwide. So you're going to have people landing on your website, not only from the United States, but from Canada and from the UK and from India and from Australia and from Antarctica, probably. And your website terms and conditions, though, are obviously based upon your country laws. And our website terms and conditions are absolutely based on federal laws. And then also some states have more specific privacy provisions and privacy laws, like California, for example. We've seen a number of business owners purchase their main client service contract, which is, their photography agreement or their planning agreement or their coaching agreement. But then they have a website, right, that their clients can land on and look at things and maybe input their information and get a freebie. And with that, with all areas of your business, you need to be legally legit, not just when you're performing the service or when you're selling goods to a client, but also in how you are communicating and right down to your website that anyone can access literally from around the world. So I know it's really good practice in the United States to have a website terms and conditions and privacy policy kind of at the bottom footer of your website. But the legalities that come into play is collecting information from a minor, having minors visit your website, having people being able to say no to you using their personal information, such as IP addresses, cookie tracking, email addresses, being able to revoke giving you their email address as well and unsubscribe. So Courtney, I would love for our listeners to kind of know the differences in Canadian website terms and conditions and privacy policies that you saw when reviewing our contracts.
For sure, yeah. So it's absolutely good business practice to have a website terms and conditions and privacy policy on your website, even if you're based in Canada. In Canada, our governing law on this is the Personal Information Protection and Electronic Documents Act, otherwise known as PIPEDA. Some provinces, though, do have their own provincial privacy laws, which would stand in place of PIPEDA. So while it's generally the same everywhere, there might be some subtle differences. I think it's Alberta, British Columbia, and Quebec that have a provincial legislation on this. So if you're in those provinces, you might, this might not totally be the same. What PIPEDA means for data collection in terms of minors, I think this was a difference based on the US one. I think the US one had an age of, I want to say 16. I think that's what you had in there. In Canada, for any child who is 13 or under, you're going to be required to get consent of their parent or guardian in order for you to collect any data or information from them. For children over the age of 13 up to the age of majority, the Office of the Privacy Commissioner recommends that the consent mechanisms be adapted to meet the child's level of maturity. So essentially what they're looking for is they want the child to know what they're consenting to, what their information is going to be used for, and what information is being collected. So those are really important to know. And then also, if you breach any of the rules in PIPEDA, you could face hefty, hefty fines. Some are up to $100,000 per offense. So it's very important to make sure that you have all of the proper mechanisms in place on your website so that you're not unintentionally collecting information from people who have not consented to it.
Absolutely. And then for like GDPR things, obviously everything still applies whether you're in the United States or Canada. Generally speaking, though, our website terms and conditions are really cross-border. They apply in the United States, they apply in Canada as well. But I'm glad you explained like provincial differences up in Canada, very similar to state differences down here in the United States. It's like a trickle effect. Usually one province or one state is going to start like really implementing strict privacy policy laws to begin with, and then other states will kind of follow suit. Same up there. So she's saying like there are provincial laws that will probably trump or supersede general federal laws or, Canadian laws as a whole, but it's very, very similar on how our systems work, whether you're in Canada or the United States. So I'm glad we chatted about that. And just to everyone listening, I just think it's really important if you are a Canadian business owner and you're looking at TLP contracts, the reason we're talking about this is because not only do you need that main contract, we just don't want you to not be 100% legally protected and fail to not have proper website terms and conditions and privacy policies on your website. That's like, I would say, the second contract that you always need to get as an online business owner. And then our website terms and conditions and privacy policy, you guys, it's like bundled together because they really do go hand in hand and they link to one another. But I always suggest that they're put on two different pages of your website because terms and conditions are for like users utilizing your website. As Courtney was talking about, minors can use your website. Obviously, people of the age of majority can use your website as well. And then a privacy policy is more for that personal information that's collected on your business's behalf from the users of your website. Hey, Legal Pagers. Did you know our contracts are available to Canadian business owners? That's right. If you are a Canadian entrepreneur, we here at the Legal Paige are now able to help you get legal and get all of your ducks in a row and help you have a rock solid legal foundation. And be prepared for all of those sticky legal situations that could come up and what ifs in the future. Whether you're a photographer, planner, coach, DJ, beauty pro, you name it, we have the contract templates for you. Did you know that when you purchase a TLP contract, you receive lifetime updates? Every time situations arise, industries evolve, and the world changes around us, so do our contracts. That is the main motto of the Legal Paige, is me and my legal team are there to revise, modify, amend, and craft new clauses in contracts that you get free of charge and complimentary when you have already purchased our original base contract. So to learn more about Canadian contracts, head over to thelegalpage.com/Canada. It is time to get legally legit and have a solid contract in place and ultimately save you time and money down the road. So Canadians, again, head over to thelegalpage.com/Canada. Again, that's thelegalpaige.com/Canada and get legit today. Okay, so Courtney, at TLP, we always try to help business owners get started from the start, right? So not only your contracts, but business formation as well. And this was something we always had to change in our contracts because you knew that people down in the United States are either sole proprietors or limited liability companies as, usually solopreneurs or small business owners. Could you tell our listeners generally what the process would be for business owners to get registered up in Canada? Because LLCs don't exist in Canada. Is that true? So what other entity options do Canadian business owners have?
Yes, it is true. LLCs do not exist in Canada. They are not an option for Canadian business owners. For the most part, business owners are going to be operating as either a sole proprietor or a corporation here in Canada. For those who don't know the difference between those two business models, the main difference comes down to liability. So, a sole proprietor, you are the business. This means if someone sues your business, you're going to be held personally liable for anything that your business is liable for. On the other hand, with a corporation, they are considered a separate legal entity, which means that you do have some liability protection. Because if someone sues your corporation, you have a degree of separation from that doesn't exist with a sole proprietor. Another big difference between the two business models is in the realm of taxation. Now, I'm not an accountant, so definitely talk to an accountant about this. But essentially, if you're a sole proprietor, any income that you earn through your business, you're going to be filing that on your personal income tax return. Whereas if you're operating as a corporation, you're going to be paying personal income tax on whatever you've paid yourself from the company. And then anything else that remains in your business, that's going to be subject to like corporate tax rates and the corporate side, but it's not all going on your personal income tax. This is a really simplified version of it, but anyone with questions on the tax portion, like I said, reach out to your accountant. I'm not a specialist on that, so always good to talk to the people who do that for a living. In terms of actually setting up your business, it's a different process depending on where you live, in which province you're based out of, because all of these are registered provincially. As I understand it, there are some federal corporation business models, but for the most part, people are doing the provincial model. So in Saskatchewan, it's a fairly easy process to set up a sole proprietorship or a corporation if you know what you're doing. Many law firms will offer this service for you so that it makes it hassle-free. Generally, we're going to need, your personal information, your mailing address, business address, the nature of your business. I don't know if this is unique to Saskatchewan, but our website that we do this on, it's called ISC. They have like a list of specific types of nature of the business. So you need to make sure it fits within one of those. And then we can do up your corporate documents, do a name reservation, order you a corporate seal if that's required, just to name a few of the steps. If you have all of that information ready for us, you can actually get your business registered in under 2 weeks in most cases, at least in Saskatchewan.
Okay, so good to know. So essentially, you guys have the same sole proprietorship model that many like solopreneurs when they're first starting out are. You're just automatically kind of a sole proprietor. It's an arm and extension of yourself. You guys, we have tons of episodes on this in the Legal Paige podcast. So go listen to sole proprietorships. Those are going to really act the same whether you're in Canada or the United States, because really every country needs to have laws and regulations regarding what happens when someone starts a side hustle, so to speak, and they're not like officially registered as a business. Because governments just know this across the world. You know that there aren't going to be like large businesses everywhere that want to incorporate. You're always going to have smaller businesses. And so it's a pass-through taxation entity in the United States, and it sounds like it's the exact same in Canada, where everything passes through to your personal tax return, but a sole proprietorship, there is no legal barrier there. All of your risk and liability is all intertwined together with your personal assets and your, personal expenses. Same with your business assets, liabilities, and expenses. So we say here in the United States, it's always good to be a limited liability company because it's like this in-between model where you don't have to incorporate and you're not going to get double taxed. You get that, like, I always like to say you get to, have your cake and eat it too, where you get that legal barrier. So it's like this other bubble of your business entity, but all of the business profits still pass through to your personal tax return, and you're only paying taxes once. So the US just really created this like kind of awesome little ditty for all of us here where we can be a limited liability company. It's exactly what the wording is. It limits your liability for your company's risks and liabilities. And same down here, you're going to register through your state, not federally, just like you're going to register usually provincially up in Canada. And then Incorporations are different. You're still going to incorporate in your state. Some people choose to incorporate, but double taxation usually isn't beneficial for any small business owner. So I usually don't recommend it unless you have lots of employees and lots of assets and it makes a lot of sense. So I'm glad you explained that in terms of the Canadian process. It sounds very similar. You guys just don't really have LLCs. So in Canadian contracts that we have here at TLP, you won't see any information regarding LLCs. You'll either put in your business name, that's your sole proprietor name, or you will put your business name with incorporated after it because you're incorporating your business. Is that correct, Courtney?
Well, with a corporation, at least in Saskatchewan, it could end with Inc., Incorporated, Limited, or Corp. Like there's a few different ways it can be ended, but it'll always have like something at the end of the business name.
Perfect. Some type of designation. So you guys, in our initial paragraph, in all of our contracts, we introduce the parties. And then we designate the parties as either like company or client, quote unquote, with a capital C. And then that's how they're going to be defined as throughout the contract. But at the beginning, you need to say who your company is. And you usually don't want to put your first name. That's like the main thing we're trying to get across here. You want to put your company's name. So say it's, I don't know, Joe Schmo Flowers. Then if you're just a sole proprietor, it would be Joe Schmo Flowers. If you are incorporated up in Canada, what Courtney's saying is whatever your designation is, usually it's like a comma and it's Inc. or Limited or Corp, whatever you choose, or whatever your province chooses for you. I'm not sure how it works up there, but that's usually how it works here. Then you would put Joe Schmo Flowers, comma, incorporated or comma, corp, period. That is important that you are really making sure that your business is the one contracting and is party to the contract. And then you, as an authorized agent or owner of the business, is the one signing at the bottom on behalf of your business. Okay, amazing. Now let's switch gears, but kind of like do a 180 turn back to where we were talking about copyright laws. Because I think we can get into a little more in-depth answer here for photographers, videographers, designers, really anyone who owns copyrights over their work. You kind of mentioned generally what copyright laws look like in Canada. And I know you had a couple examples that were very interesting for probably Canadian business owners and photographers in general listening in. But can you own common law rights to your copyrighted work immediately? What about registering copyrights? How does that kind of play out with copyrights and intellectual property clauses within these types of contracts? Because here in the United States, we do have common law rights to our copyrights, but to actually own them and defend your copyright, usually you have to register them federally through the U.S. Copyright Office. So I'd love to know how it works up in Canada.
Right. So I did touch on this a little bit earlier, but to get into a little bit more detail now, the short answer is yes, we do have common law rights. All of these works like photos, videos, designs, etc., they would be considered artistic works within the Copyright Act. As I said before, the copyright is created the moment the work is created, and the copyright owner is the person or entity who owns the camera or other medium that the work was created on. For example, I kind of talked about the photography one before, but for someone who's taking photos, say, on a vintage film camera, this is a little bit different because the camera itself is not what the image is on. On a digital camera, the image is stored on the camera, so that's the medium. On a film camera, the copyright is actually going to be owned by the person who owns the physical film that the photo was taken on. So in most cases, this is going to be the same person who took the photo, but it's still an important distinction to know because this means like a business could technically own the copyright to certain photos and works. If your business purchased the camera, they're the owner of the camera. Your business owns the copyright to the photos you take on your digital camera. You're not required to register your copyright on photographic work. It's an automatic right that you're given. You can take that extra step if you'd like to, but you can still assert your copyright rights if they're being violated, even if you haven't registered a copyright. So What people are still allowed to reproduce your work, though, as long as it's not for commercial purposes. So your copyright doesn't mean that, nobody can post your work ever without your consent. If you're taking wedding photos, your client can take the photos and they can post them online or print them at home, circulate them amongst their family. As long as they're not reproducing it for commercial purposes, then that's allowed. Where copyright becomes a bigger issue is when you're doing commercial or branding work for a client, because in some cases, they're going to want the copyright to the work because they're using those images for commercial purposes. So it's common that this is going to happen. It's also easy to assign your copyright in this instance. We do include that specific clause, I think, in the branding and commercial photography contract template that we've done. But essentially what it's going to do is it assigns the photographer's copyrights and their moral rights in the work to the client. Moral rights, I'm not sure if the US has an equivalent to this, but it is a unique feature of our Canadian copyright law, and they exist to preserve the integrity and intent behind the author's creation. So you can choose to retain these and also assign the regular copyright to your work, or you can assign all of it, just handing off those photos to the client completely solely. If you do choose to assign your moral rights, it has to be made very, very clear. It's not, you can't assign a broad clause to this that just says, I assign all copyright in my work. You specifically need to state that you are assigning your moral rights in the work to someone else. This is important to know also if you're hiring an associate photographer or videographer, if you're wanting them to assign the copyrights in the work they produce under a contract with you. If the moral rights are not assigned, you could be liable if the original author wants to assert those moral rights and didn't give them over to you. I know that's different than US law. Independent contractors here, there's no works for hire provision in our Copyright Act. So regardless of your agreement, your independent contractor is going to own the copyright to any works that they produce. And then one final thing to know about copyright in your work is that, yes, it automatically is created when you create the work itself, and it will automatically last for your entire lifetime. And then the copyright will expire 50 years after you die.
So interesting. There's so many overlaps. With the United States and Canadian laws. I mean, I'm just sitting here nodding my head being like, yep, same here. Yep, same here. But those key differences are really important in terms, I think the moral rights is the biggest thing. We assign basically full copyrights over to people or limited use for commercial purposes kind of thing. So those were the big changes in our, when Courtney was reviewing our template contracts and converting them for Canadian business owners, she made sure to have all of that wording very clear, just based upon Canadian case precedent. Now, Courtney, you were talking a little bit about independent contractors, so I think we should touch on that. I would love to know about employment laws up there because it's always a freaking hot mess here in the United States, and every small business owner is probably laughing with me right now because it is. And I feel like it's super political and things are constantly changing down here in the US. And it's also state-based, but they tried to make it federal a couple of years ago and it did not pass and it did not go through. And we've got gig worker laws and people just like running their own businesses here. And then they like working on the side as contractors for other people. And then the government tries, usually more progressive politicians try to implement some more employment labor laws on top of that, and people don't like it. I think across the board, depending, no matter what political spectrum you're on, if you are a business owner and you like working different gigs for different people, you just don't want to be regulated to that extent whatsoever. You don't want to have to be an employee for someone and all of that comes with it. So do independent contractors differ in Canada? And here we really have a main rule about contractors. And I just want to make that clear to everyone. They have to be an independent business based upon the word independent in the actual title of what type of worker that you are, an independent contractor. You usually have to send your own invoices for services. You can terminate at any time. And then usually you have to be your own business. Like you have to be set up as your own business and sending invoices to the people that you're working for. Usually have your own business insurance, so on and so forth. It's all about control. The person that you're working for can't have full control over you, or you really look an awful lot like an employee here in the United States. And then we have this like new issue with 1099s. If you are in the US, you know what I'm talking about. In Canada, I would love to know, Courtney, how it works up there. But they recently just changed the laws here in the United States as of January 1, 2022. And what it is no longer are 1099 miscellaneous forms sent to people. It's called 1099 NEC forms, non-employee compensation forms. And it's a way for the federal government to tax people now because people are getting paid via PayPal or Square or Venmo Business. And all of that was kind of going untaxed. And the government is starting, I think everywhere around the world is starting to realize like everyone's doing things online and we need to like get more money for tax purposes for our government. And so we were only required here in the United States, if you were a business owner, to send a 1099 miscellaneous form to people that made over $600 for your business. But now it's like PayPal is required to send what's called 1099K forms for anyone who makes over 600. You're required to send 1099 NEC forms. If you didn't pay via PayPal and you paid like cash, check, or direct deposit, then you are required to send these forms. So how does it work in Canada with independent contractors, I guess is my question. What like forms are you sending and like are they kind of the same in terms of how they're regulated?
Okay, so when it comes to our employment law on independent contractors, it sounds fairly similar, but there's definitely a few differences. So what really matters here is the nature of the relationship. So you can call anybody an independent contractor, but if you're going to be audited by the CRA, they're going to look at the nature of that relationship regardless of what you've labeled it. So the CRA actually has a document they put out that has a fairly comprehensive guide on what factors they're going to look for when determining if someone is an employee or an independent contractor. But it boils down to like four main components. So the first one is control, which you talked a lot about. That's what matters in the US. It's very similar here. So they're going to look at if one party has control over the other, specifically over like, when they're working, what they're being paid, not necessarily over the end product, but over their working conditions. If the worker is permitted to work for other businesses or other people, if they can't set their own schedule, these would be an indication of an employee-employer relationship. The worker should be free to work when and for whom they choose if they're an independent contractor. The second thing they're going to look at is ownership of tools. So independent contractors generally will supply their own tools and equipment for a job. So in the case of, say, like an associate photographer, they're bringing their own camera and any other accessories or tools and equipment they might need to photograph an event. Third, they're going to look at the chance of profit and risk of loss. So an independent contractor has the opportunity to make a profit, but they also take on the risk of loss as a result of, bad debts, damage to equipment and materials, or delays. Typically, if you cover your own operating costs, you're going to be considered an independent contractor just based on that. If the person you're working for is, covering those costs for you and, you're guaranteed that money regardless of what happens, they're maybe going to think that's more of an employee-employer relationship. And lastly, they're going to look at integration. So this one is a little bit less clear about what they mean, but generally speaking, if you have multiple clients, you're not exclusively working for one person or one business, this should prove that you are an independent contractor. Having only one client creates a perception that it's an employee-employer relationship because you're only working for that one business. So there's going to be this perception that they might have some sort of control over you. It's really important to make sure that you're clear about your working relationship with anyone that you hire, because if the relationship is found to be an employee-employer relationship, it's going to have repercussions for you as a business, because as an employer, you're required to make deductions for employment insurance, for CPP, among other things. And if you haven't been doing that, and then someone is designated an employee by the CRA, you're going to have to pay back that money to the government. One big difference, though, is if someone is truly an independent contractor, you are not going to be required to send them any sort of tax documents at the end of the year. You're not providing them with a T4, which is our main document that you would get from an employer. We don't really have any sort of document you would send to an independent contractor, because essentially they're providing you a service, they're sending you an invoice, you've paid that invoice, they will then file their own taxes. So there's no link between the taxing for the two.
That's fascinating, mainly because I'm like, why is the United States so dead set on regulating all of these through tax forms? I think it's because everybody just likes tax evasion here in the United States. If I'm going to put my finger on the issue. And our governments are just really poor, and so they need more money. Also, you guys' tax rates are a lot higher up there, and I think everyone just kind of pays into things a lot differently than here in the United States, and state tax laws are different depending on where you live here in the United States. So very fascinating, because lots of things have changed here in the U.S. As if you remember, early 2020 was the AB5 law that came out in California. And it basically stripped all of these contractors, including Uber and Lyft and all of these gig workers, from being contractors, and they had to be more employees. And they were trying to mainly hit big corporations from allowing people to be contractors, and they really wanted to give them rights as employees. But then the trickle-down effect happened, and it really hit small business owners hard, who can't afford to hire people as employees, who have workers that really just want to be contractors and make a little bit of side money. And so that didn't fully go through. There's a lot of exemptions to that. There's a lot of things that have happened with that law. But then AB5, when President Biden came into play federally, then the Biden administration tried to change some things federally, kind of tangentially related to AB5. And I'm saying this because AB5 has those provisions and those steps that you were talking about, Courtney, regarding what are the factors that you're going to consider if you do get audited, essentially. And they're this looks like an employee. And then you're no, this is a contractor because of XYZ that they've done. At the end of the day, that's what we're telling you guys. Whether you're in the United States or you're in Canada, do your due diligence. Make sure they look like a contractor and not an employee, and get your legal ducks in a row documentation-wise, so that you have arguments that you can present if you do get audited and they do try to say they're an employee. You don't want to be subject to all of those penalties Courtney talked about. The same goes for here in the United States. You're going to get hit statewide and federal-wide if they do end up looking a lot more like an employee. Okay, staying on this topic of the overall contract as a whole, we've talked about contract provisions. We've talked about differences with copyright clauses. We've talked about differences with contractor clauses. What were a few other things that are notably different in Canada? One that I was surprised at, I guess, was the distance that some have to travel to the closest courthouse. And Courtney and I voxered about this for quite some time. I was like, wait a second, how can we make this more templatey? How does it work up there? Where are you guys at, and where is your courthouses? So I understand how spread out Canada is, and I know other Canadians, they've talked about that before too. They're like, Paige, mileage doesn't happen, it's kilometers up here, all the things. So I guess when you said it, I was surprised at first, but I knew that it was going to impact our venue and jurisdiction template clauses and our arbitration and mediation template clauses. So Courtney, could you just give an overview here of why it's a lot different up in Canada versus the US, where we basically have courthouses in every single little tiny town?
Yeah, absolutely. So I think this is surprising for a lot of people, even many Canadians who maybe live in a larger center and aren't familiar with the smaller centers and the rural areas. So if you live in a city, this is really not going to be an issue or something you would ever come across because all of the major cities have courthouses. Lots of them have more than one courthouse. But for many people, myself included, we do not live near a judicial center. So, for example, I live 125 kilometers from the closest courthouse in my judicial center, which is about a 1 hour and 15-minute drive for me. The reason this is important to note for the venue and jurisdiction clause is that the business owner is going to want this to be the most convenient location for them. So if you don't specify a jurisdiction, it's going to come down to whoever files a claim first. If your client is from even, say, like another province, I mean, most of the time you're going to have at least it'll be, a provincial restriction, but say they're in another town even. If they file first in a different judicial center, that's where it's going to be. So if you're going to specify in the contract, you want to put wherever is closest to you, because chances are you're going to need to get to that courthouse at some point in time. You always want to make sure that venue is going to be where you reside and where you run your business, at least closest to that. Otherwise, you're going to have extra costs because you're going to be traveling. You might have to take a day off of work for doing so. So there's just a lot of hidden costs you might not have factored in that you wouldn't necessarily think is important. It's the same idea for the arbitration clause as well. You want to make sure you're setting a location as close to you as possible. That's going to be the most convenient and cost effective for your business. The only difference being that arbitration doesn't necessarily have to take place at the courthouse. So you might be able to get away with saying, arbitration is going to happen in this location, or you could even specify, I think if you wanted to, that you're okay with like a video arbitration. Those have really come up in the time of COVID. We do everything on like video chat now. So that's going to be a big factor for you. And otherwise, it's really just about protecting yourself, protecting your business by being as clear as possible so that you don't have to deal with any unexpected costs if a dispute does arise with a client.
Gotcha. Yeah, similar, but quite different as well. Here, the main thing that I just want to take away for everyone is you always want to find the closest judicial center for you or courthouse, like here in the United States, for your business. And I also just want everyone to know that these two clauses, the venue and jurisdiction clause and the arbitration and or mediation clause, most of ours are just arbitration clauses at the Legal Paige, are negotiable. And it's one of those contract clauses, these two, that get negotiated most often. And your clients are sometimes litigious clients, or if you have lawyers as clients, they will try to like make the jurisdiction and venue closer to them. And it's really important that you're protecting yourself as a business owner and you're keeping it within your region, just for like cost purposes as a whole, especially when they're only paying like a few $1,000s for your services. We're not working with big corporations here where we're dealing with like millions of dollars worth of like contracts that you have through somebody. That's when these clauses get more negotiated. And, you can like give and take in a contract with lawyers, and they're going to like try to change this clause and then change another provision, in lieu of it kind of thing. So I'm glad you explained that, Courtney. The last thing I wanted to chat about was this one clause that you added at the end of every single contract that is not here because we don't have this clause in the United States. It's the no contra proferendum included clause at within the general provisions of our contract. So we don't call them, you guys, here at the Legal Paige. We don't have like a whole section that's deemed miscellaneous or general provisions or boilerplate language. We just put those clauses at the bottom of the contract. So they're similarly placed in all of our template contracts, but we like the contract to be as a whole living document itself. But Courtney, you put this at the very, very bottom of each contract that you worked on for us. And can you tell us why?
For sure. So contra proferentum is a Latin maxim that translates to against the offerer. So typically we see it used in Canadian contract law as like a last resort when a contract clause is ambiguous. And it means that the ambiguous term will generally be interpreted against the person who put the term in the contract. So this is why it's important to include the no contra pro forentum clause, because it serves to protect the person who arranged for the drafting of the contract. So in our case, it'll typically be the business owner. The intention of the clause is just to negate that presumption of contra pro forentum in cases where a clause is deemed to be ambiguous. Like, it really, really is a last resort, and this rarely will be an issue. But just to totally cover our butts, we put that in there because contra preferentum really is a presumption. So we want to make it clear that we're saying this presumption does not apply.
Love it. Super clear, very legal mumbo jumbo, unjumbled for us, essentially. I needed to know that because I was like, this is interesting. I read the clause and I understood it, but the title of it seems a little like, oh, God, a lawyer wrote this.
Yeah.
And for US-based business owners, you guys, if you're listening in, we do have like a headings clause that essentially kind of has some of that like presumption things that the title of the clause really doesn't apply to like what's actually the written legal language in the clause kind of thing. So it's just interesting that was at the end of every single contract that we didn't have here in the US. All right, Courtney, that was so helpful. Is there anything else that you would like to tell Canadian business owners? Just leave them with one good solid tip that you would like them to know.
Okay, well, I think we covered so much of Canadian contract law today. And really, the biggest tip I can give any Canadian business owner is to invest in protecting yourselves. So don't just take a contract that you found online, that you Google searched and you're like, oh, perfect, a contract print, that's what I'm going to use. Please, please, please do not do that. Usually an online contract that you find, it's not comprehensive enough to cover everything that you need. And in some cases, they might be missing entire clauses that are vital to your industry. It's also really important from the client's perspective because they need to know what risk they're taking on. And it should also be very clear on how your contractual relationship is going to work. Most contractual disputes happen because one party didn't understand their rights and obligations. So we want to make sure that does not happen to you. It's never good for business to have angry customers. So it's great if you can just start with a very clear contract that outlines what your relationship is going to be. I know it seems like a very boring thing to spend money on, but you have no idea what unforeseen circumstances might come up in the future. And you just need to protect yourself and your business. It is so important to make sure that you are legally secure as a business owner. And I just cannot stress that enough.
We're such contract lawyers over here being like, it's so important, but it really is. And we're going to stress it time and time again. That is our job. That is what we became lawyers for. And now what we get excitement about and what we're passionate about is we want you guys to feel protected. We want that ease and, stress off your shoulders, knowing that you are ready for any of those what if situations here in the United States and up in Canada. Courtney, we are so excited to have you here as a part of the Legal Paige, as our Canadian lawyer. You guys, if you have any questions regarding Canadian contracts or running your Canadian business, please hit us up at the Legal Paige. You can ask us in the Legal Paige community on Facebook. Me and my legal team are in there. Courtney is now working with us and helping with all of our contracts. So she's definitely here to answer questions. She's not your lawyer, so she's not going to be able to answer one-on-one questions, but you guys know the drill, and we'd like to answer questions in more of a general forum so that all types of business owners can get, the same answer to your question. If you have it, they probably have it too. So thanks again for tuning into this episode. And Courtney, thank you so much for joining the Legal Paige and being our go-to Canadian lawyer. We are ecstatic to have you, and we are so excited about our Canadian contract catalog.
Awesome. Thanks.
And wrapping up today's episode, as you can see, we are all excited to now have Canadian contracts available in the shop. I am so passionate about helping entrepreneurs get legally legit, and to be able to extend that help to our neighbors over in Canada is a big deal. Ever since the Legal Page was started, I received countless emails, DMs, messages, all from Canadian entrepreneurs asking why they couldn't buy our contract templates. And we really had to share everywhere that it was really only for US-based business owners because that's where my legal team and I are based out of in various states in the United States. And it really broke my heart. So I wanted to help everyone as much as I could, but I couldn't create Canadian contracts and have them be legit without having a Canadian lawyer on board. So for a number of reasons, but as you heard today, there are big differences between some of the laws in Canada and some American laws and American state-based laws. And that's why I am excited to have our Canadian gal, Courtney, on our team helping us as a lawyer up in Canada. She has been a major piece in getting our Canadian catalog set up and is currently working through converting all of our remaining TLP products to be living Canadian legal documents for you to purchase and use for your small business. So the biggest takeaway I have for Canadian entrepreneurs listening today, and really all entrepreneurs in general, is that now is the time to get legit. Now is the time to get protected. Now is the time not to shove things under the rug for another day. Your contracts are so important for your business. They are living documents. They are there to breathe with you, to move with you, and to help you in times of need, which I've said over and over again, but it's so true. They set the tone in your working relationship with clients, and it's important that you feel very protected and comfortable with your existing contract. So go to thelegalpage.com/Canada today to see all of the contracts that we have available in our Canadian catalog for you as a small business owner. Thanks again, and we'll be back with the next episode next week. Thanks so much for listening to this episode of the Legal Page podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpage.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.